Ladies and gentlemen, welcome to our panel. Our panel, we're going to discuss the rule of law, Chinese perspective. Firstly, let's extend our heartfelt thanks to all the delegates, all the organizers of the World Law Congress, New York 2023, especially the World Jurist Association, which is also celebrating its 16th anniversary. As the Vice President of World Jurist Association and China Law Society, our association and the society have invited over 20 Chinese delegates to this Congress. We are looking forward to well-founded, open-minded, and judicially communication, making peace through law and rule of law. As we know, the rule of law is a common value of the world. The rule of law, in my idea, is the basic and best way for human beings to find out, govern the country, govern the society, govern the global issue through hard exploration. So in this panel, we have invited 7 excellent speakers with 4 different nationalities. I just want to mention that, we just have 1.5 hours for this panel. So, and I hope each speaker will control your time in 8 to 10 minutes. I just want to introduce panelists. The first speaker will be Dr. Li Jiankun from China University of Political Science and Law. Second speaker will be partner Yidu Tillinghast from Sheppard, Mullin. Third speaker will be Dr. Peiwei from Beijing, Yidu law firm. Fourth speaker will be Juris Campos Falcones from the BB&CC Consulting, China. Fifth speaker will be Professor Tang from University of International Business and Economics. Sixth speaker will be Professor Tong, who is Associate Dean at Wuhan University Institute of International Law. Our final speaker will be Professor Shenjian, Dean of School of Jurist Master, China University of Political Science and Law in Beijing. Now, we have first speaker, Dr. Li Jiankun, to take your microphone, please.
Thank you, President Huang. For me, it's really a great honor to be here to share with you some of my personal observations on the topic of rule of law China, and especially for such a young scholars. So I really look forward to your comments and your feedback. Let's just go to the same. Like our conference today in the opening ceremony, we mentioned that the topic today is the making peace through law. So firstly, when I came to this topic, when we discuss about peace, for me personally, the first word that comes to my mind is security. Although in such a diversified world, maybe not for every country or for everyone, the security is the most important thing within the concept of peace. However, it must be one of the connotations of peace. So therefore, I will share my view on the China's role and its latest efforts to the global security governance. So global security issues are very complex and also very sensitive. Regional and inter-regional conflicts are still increasing, and we can see the trend of the generalization, especially today in this opening ceremony. Everyone mentioned that we are in a very struggling day. Therefore, in the absence of the global security governance, China has put forward a global security initiative to further stabilize the global security situation. This is also another important public good provided by China to the international community. The concept has been gradually formed through the continuous development and improvement. So today I will just to focus on three parts of my presentation. The first is the background, the second is the value, and the third is the practice. So for the background, today the theme of the peace and development still faces so much severe challenges, like the geographic confrontation, the unilateralism, the traditional and non-traditional risks. So they are all intertwined and transforming from each other. China has launched a global security initiative. By launching the initiative against the context of prominent global security challenges, China has been demonstrating its responsibility through a peaceful way, not by force, like our theme of the Congress. As a major country at such a critical moment concerning the world peace and development. Like two years ago, if I remember correctly, at the opening ceremony of the Bo'ao Forum for Asia. By the way, Bo'ao is located in the very beautiful China Hainan Island. So I wish someday you will visit that. It's a very beautiful beach. President Xi proposed the Global Security Initiative for the first time in that speech entitled Meet Challenges and Create a Future. And the GIS, we call it the concept paper, issued the 21st February this year, so it's just like 5 years ago, defined its core principles as the 6 principles. So the first principle is adhering to the concept of common, comprehensive, cooperative, and sustainable security, and jointly maintain the world peace and security. Second is adhering to respect the sovereignty and the territorial integrity of all countries, non-interference in the internal affairs of other countries, and respect the development paths and the social system independently chosen by the people of all countries. Third, adhering to the purpose and the principles of the Charter of the United Nations, abandon the Cold War mentality, oppose the unilateralism, and refrain from group politics and camp confrontation. Fourth, adhering to emphasize the legitimate security concerns of all countries, uphold the principle of indivisible security, build a balanced, effective, and sustainable security architecture, and oppose building one's own security on the basis of other countries' insecurity. Fifth, adhering to the peaceful resolution of differences and disputes between countries through the dialogue and consultation, support all efforts to resolve crises peacefully, refrain from double standards, and oppose for the abuse of unilateral sanctions. 6, adhering to coordinate the maintenance of security in both traditional and non-traditional fields as a whole, and jointly address the regional disputes and global issues such as terrorism, climate change, cybersecurity, and biosecurity. So these 6 principles fundamental to China's global security initiative. That's what we are doing right now. The second part is about, so what's the value of the China's global security initiative? For me, I mean, it's just my personal perspective. I think the global security initiative actually strives to break the dilemma of the absence of global security governance and advocates the international community to jointly safeguard the world peace. Due to the absence of global security governance, the peace deficits, the political bullying, and the opposing camps have become more serious. The Global Security Initiative provides by China a solution and wisdom to address the global security governance crisis. The Global Security Initiative actually integrates the Chinese culture of 以和为贵, is a Chinese saying, and we may translate it to the harmony is the most valuable. It's a very traditional concept in all the Chinese people. Even you ask any Chinese child, they all know this. It is rooted in China's traditional culture and independent foreign policy and practice of peace, and is a concrete manifestation of China's deep concern for the common destiny of all humankind. The Global Security Initiative has put forward a new path of security governance featuring the mutual respect, the fairness, the justice, and the win-win cooperations. From the perspective of the well-being of all the mankind, it actively promotes true multilateralism, abandons the zero-sum game, eliminates the root cause of conflicts, and advocates win-win thinking to address security challenges and achieve the lasting peace and development for all the world. At the same time, the Global Security Initiative is also an important part of the theoretical system of a community with a shared future for mankind. Since it was put forward, it has received wide support and positive response from the international community. As far as I know, I checked yesterday actually, at present, over 60 nationals or regional organizations have clearly expressed their appreciation and support for the Global Security Initiative. Therefore, the Global Security Initiative has provided a strong driving force for the strengthening global security cooperation. China will continue to appeal to the entire international community to work together to maintain the world stability and harmony. So last but not least, I would like to show you some practice since the launch of the Global Security Initiative. China has actively participated in the reform and the development of global security governance system. The initiatives has been written into the declaration of the Riyadh Declaration of the First China-Arab States Summit, also written into the joint statement of the meeting of focal points for the implementation of the outcomes of the 8th Ministerial Conference of the Forum on China-African Cooperation, and was included in China and Kazakhstan, Uzbekistan, Belarus, Vietnam, and other countries' bilateral joint statement. So take the practice related to the United Nations as an example, because we are going to United Nations headquarters tomorrow. So in August 2022, China has, as the rotating president of the UN Security Council, proposed that the Security Council hold an open meeting with the theme of strengthening dialogue and cooperation to safeguard common security. During the meeting, members of the Security Council had in-depth exchanges and on the fundamental issues concerning the international security. Also, in the December 2022, it's half a year ago, China's second summit, the international cooperation in the field of international security resolution, to the 77th of the UN General Assembly Disarmament and International Security Committee, and it has been adopted. The resolution emphasizes the peaceful use of science and technology and related international cooperation on economic and social development, urged the countries in the proliferation of international obligations at the same time, lifting the unreasonable restrictions on the peaceful use of science and technology in developing countries. Last year, 2022, also marked the 30th anniversary of China's first Blue Helmet Force participating in the UN peacekeeping operations. So actually, over the past 30 years, China has sent more than 50,000 blue helmets, with the largest numbers of peacekeepers among the permanent member of the UN Security Council. Actually, we have more practice regarding the Global Security Initiative, and we do look forward not only from the practice, also from the academic, from the jurist, from the, or maybe we have more practice with the legal case, and we do wish that the Global Security Initiative could make a really contribution to all the countries. So to sum up, China has unswervingly maintained world peace and unswervingly followed the path of peaceful development. As a responsible country, China has continuously set new milestones on the path of achieving lasting peace and universal security for all mankind. And I really hope that it has been and it will continue lighting up the hope for peace in the hearts of people around our peaceful world. Thank you so much.
Thank you very much for your wonderful presentation, talking about peace and security, which is basic value of our world. I think it's an excellent start of our panel discussion. Now, our next speaker is, how do I pronounce your name? It's difficult for me.
It's Tillinghast.
It
looks confusing, but if you pronounce it just the way it's spelled, it's very easy.
I'm sorry. Yeah. Who is a partner of a very famous law firm. Yeah. Now it's your turn.
Thank you. And I'll pass around. I sort of pulled some highlights. I'm Ed Tillinghast, and I'm a partner at Sheppard Mullin here in New York, and I've spent the last, 27 years since the Asian financial crisis, largely focused on a sort of different angle, I'll say, from the professor, of a more commercial side of an American lawyer's involvement in China, representing largely funds and corporations from Hong Kong, the UK, and the US. In investments in China. And as you'll sort of see from my comments, I'm a restructuring lawyer, and I work in a financial distress world. So for good or for bad, what I see is a troubled investment, and that's why someone would hopefully come to me. But so my involvement with the importance of rule of law is focused on China because originally it was an academic interest that I had in China, and then I sort of married my legal side to my academic interest. And one thing that I'd like to say that in working in China as long as I have from the US, I've always been based, but I've spent a lot of time in China. There's a tremendous amount of progress in the rule of law in China. And I think back, and I've often spoken about how you look at, we US lawyers look at where we are today, or the UK is, or continental Europe. And when you compare that to China, when you look post-Cultural Revolution, at the advancements that China has made, it's truly tremendous. And I say that up front because that amongst American businesses, you often hear criticisms and frustrations of doing business in China, but I think you do have to put it into perspective and look at just how far, from a commercial law perspective, China has come in, in the scheme of things, a relatively short period of time. And just in my relatively, 25, 30 years, I've seen a huge progress within China. And I remember in the course of 10 days, I met with the Chinese ambassador to the United States in Washington. And just before that, I met with the chairman of the Securities Regulatory Commission in China. And ironically, they both had the same comment to me. And I went through in a very, I'll say, politically correct presentation of, I was representing a group of bondholders in a defaulted infrastructure project. And I was explaining the value to China to basically allow the legal system to do what it's meant to do, both in China and in the US. And whoever wins or loses, that's right. It's not a question of who should win. It's a question of allowing the legal process. And I raise this because this is the beginning of a progress in my window. Both individuals, when I went through this very carefully planned out presentation, were listening astutely, and I thought I was making progress. And at the end, they both said the same thing. Of course we respect law when it works for us. And that's a very contrast to what you see today, I think, in China. That was in about 2004. Today, there have been a lot of legislative reforms. There has been a lot of reform in the judicial system. The level of judging that I've seen, particularly in some of the larger cities, is much better than it once was, and certainly better than it was before I started engaging in China. And just to highlight some of the laws, which I tried to, this is not a comprehensive list, but the foreign investment law, which was passed in 2020, opens up foreign investment into China considerably. It makes it much more transparent. It also reduces the so-called negative list from 63 sectors to 12 sectors and China has its sectors. We have our sectors. We have CFIUS in the United States that prohibits investment in anything that touches national security, and it's a similar type thing. And when you look at the different types of businesses that are precluded, it makes good sense for China to want to preserve that. And so it's largely on the tech sector. But the foreign investment law has opened things up tremendously. It also allows for currency to come out of China much easier from investments. And that back around the time of the Asian financial crisis was a major problem. You just basically could not get it out of safe, or it was a multi-year process. And to an American investor, particularly whether they were a par buyer of bonds or a distressed buyer, particularly a distressed buyer, and be it a hedge fund or a pension fund that was invested in distressed debt, anything more than a nanosecond is a million years. So going through an administrative process that took, in some cases, years was really not acceptable, but that's improved tremendously over the years, and part of that came about in the foreign investment law. The enterprise bankruptcy law, which is for commercial enterprises, is in some respects, it's modeled after Chapter 11. I got fairly involved in the drafting of that to enable a restructuring or to enable a liquidation if the company really shouldn't survive. And that's a big improvement, and there's been a number of relatively successful either restructurings, or the reality is that some companies shouldn't exist and they need to be liquidated. But that's a decision that a court should make with a fair amount of transparency. The level of transparency generally has increased dramatically. There's a lot more online. There's more online filings. Some of it is on a test basis. But to me, as an American lawyer, representing Western interests for the most part, although I've represented a fair amount of Chinese companies, those sorts of things are very important to a Western investor. So when I think of rule of law in China, and those advancements are very important to the Western world, because as the professor indicated, I mean, the more we can work together, the better we are, and those become obstacles in the commercial sense. If a company doesn't feel there's a transparent judicial system or a judicial system that works. Another one that, one of the remaining frustrations, I think, of many Western investors is for, other than a select group of countries where there's treaties where China recognizes foreign judgments. For the most part, China does not recognize U.S. judgments or many foreign judgments. But nevertheless, it is a signatory to the New York Convention for Arbitration. So arbitration awards can be readily enforced, which is a good thing. And maybe aside from some of the judicial reforms, one of the things that I've seen the most progress from a Western commercial perspective is the CTAC arbitration, which has gone through its cycles of okay to problemed to, in my view now, it's a very successful vehicle for resolutions of disputes. And then there's a few other, like CTAC, there's one in Shanghai, and I point those out. But my general view is that there's been a tremendous amount of advancement. A lot of it is respecting the transparency that many investors require or demand. And that will further relations on a commercial level between Western companies and Western business and businesses from China. And I see that as very positive. So I welcome any questions, or we can go to the next speaker.
Thank you very much, Mr. Tillinghast. You gave us a wonderful speech about important business considerations for doing business in China. In China, now we pay more attention to the rule of law for doing business in China. President Xi Jinping said the rule of law is best environment for doing business. That's a good thing, I think. Mm-hmm. So now we focus on the rule of law in foreign matters, in relating foreign affairs, including business. So I think with the development of the rule of law in China, the environment for doing business is become better and better. Thank you. Our next speaker is Professor Dr. Lu Peiwei from Beijing. Now,
thank you, Professor Huang. My name is Lu Peiwei from China, and you can call me by my English name, Sam. When we Chinese begin to study English, our teachers often ask us to choose an English name. One of the reasons, as my English teacher explained, is to create an English-speaking environment that facilitates language learning. As a former public prosecutor and a lawyer, I believe the concept of the rule of law, just like our English names, our Chinese English names, may be perceived differently by native English speakers. We live in different environments, and for Americans, Britons, for Westerns, the idea of the rule of law is not without uncontroversy. In general, it expresses the principle of that nobody is above the law. However, in China, most Chinese often rely on leaders who they believe understand the law best and who could protect their demand for justice rather than the law itself. For instance, in many areas and for the majority of average Chinese, when they face criminal charges or become victims of criminal cases, their first course of action is not to seek professional legal assistance, but to use their social connections to influence the policemen, judges, and prosecutors who handle their cases. They believe that if their social connections, often powerful individuals, are strong enough, their cases will be favorably resolved. Even some judges, prosecutors, and law school professors share the belief that defense lawyers in criminal cases in China are of little use, as they assume these lawyers merely have better familiarity with criminal procedure than the average person. So, as a former prosecutor, from this perspective, I think the rule of law should center on the law itself, while for Chinese and in China, at least now, it revolves around having wise and just leaders. Only when such thoughts and ideas are redirected through education or other means can the true seed of the rule of law break through the soil and emerge. Maybe you cannot imagine in our real life, Chinese real life, when our children, they need to begin to accept education, or we need to go to see doctors, the first we think is not by rule, but to seek our social connection. It's true. It's though Beijing Yidu law firm, my work unit, we have many excellent former judge and former prosecutors from the Supreme Court or different level courts in China. But we think not. We are pursuing rule of law, just like veterans understand, to do some do our efforts to Chinese rule of law career. That's all. Thank you.
Okay. Great. Thank you. Thank you very much for your speech. Dr. Lu Peiwei talking about the relationship between the social connection and the rule of law. That's very special in China. This issue, I think, is should be take care of it. Our next speaker is Juris, Campos, Falcones, who is responsible for the legal affairs at BB&CC Consulting China. Now the microphone is yours. 来了吗？没来啊？ Okay, that's fine. Okay, now,
Yeah.
yeah.
You talk about social instinct. Are there recusal rules for judges so that if there's some sort of, people in this country see any advantage they can too. I don't think that that's unique. What we try to do here is have rules to guard against bias as a result of that, especially in the law. So we have, for example, recusal rules, so judges with the emotions law, just recuse themselves if they're conflicted. Are there conflict rules and recusal rules that are part of the Chinese judicial system?
Basically, yes,
Maybe-
I think.
Yeah, I mean, of course, I mean,
It's
Maybe you.
basically, yes, I think.
yeah, I mean, maybe Dr. Lu didn't make it so clear that he was talking about in the last past years, or sometimes the social connections with the law, with the rule of law, it's a question. But recently, when we pay much attention to the rule of law from the Chinese government, that has been improved. So that's what we are to be so frankly to. Yeah, that's more like the past story, and we're talking about that. We are trying to resolve the bias or the other thinking of the Chinese rule of law from the other people, like the connections and the rule of law. Actually, it is we may admit that in the past times especially, there are some problems, but I don't think there's a unique problem in China. It's also a worldwide. Yeah, that's right. So we can really admit that, and but we really think that we have made big progress in this. So that's, of course, when you mention that, the judges or the other legal practice, of course, will be accused of that, and it's very severe penalties under the Chinese law. And everyone knows the Chinese part, the criminal law for such things are so very strict about that. Thank you. Hope I can answer the question. Thank you.
Okay, thank you. Maybe we can give our mic to next speaker, Professor Tang Lin. Professor Tang Lin is practicing law in China and Australia. Now it's your turn.
Thank you. Do we still have microphone, or do we have?
Yeah,
okay.
Just for the recording, so
Okay.
the sound in this room.
Oh, okay. All right. Thank you. It is an honor to attend such a splendid conference here in New York, the place that practiced the rule of law ever since the foundation of this country. Well, my story is a bit different, and it can be quite used as evidence in respect of China's rule of law development. Just like Ed just said, okay, when we look at the rule of law China, we have to put it in perspectives. Well, China was, when I was young, we just finished the Cultural Revolution and all. So post-Cultural Revolution, over 40 years development is also a development of rule of law. We have to maybe, from that perspective, we will see China better and understanding China maybe more thoroughly in this area. I was educated, well, I was trained to be an engineer when I was young, because by that time, China has a saying that if you learn the math, physics, chemistry, you just fearless going anywhere. Not law. Now maybe it's law. After work for some of the quite important organizations in China, I went to overseas, initially New Zealand, to pursue a chemical engineering PhD. Then I went to Sydney, Australia, and started my Bachelor of Law from scratch when I was 30 years old. And then I became a practitioner, ever since. I worked for Baker McKenzie before, of course, Campos in Australia. In 1999, I set up my own law firm, just called Lin Tan & Co. Lawyers, and mostly serving Chinese community in Sydney, and also some other, community people. From my client perspective, when I, see the client changes in terms of the perception of rule of law in Australia. What does it mean? It means that initially, when these Chinese business people went to Australia, all they want to do is to know the government officials. Okay, they think that knowing government official is the key to do the business in Australia. Well, it's not. But it's the way, my perception is mostly doing business in China, just like Professor Lu just said. Nowadays, and ever since, I think, 2012, just like Professor Li Jiankun just said, as a tradition in China, we always using the term he, but it's been translated as harmony. It actually can be harmony and also can be peace. Now, we are in the conference that, have the icon called peace through law. And China, basically, to achieve peace, not just by law, by anything. Okay, and we also call it harmony. And but ever since 2012, I think rule of law has been put into the spotlight. And the current leader actually already developed. It's called Xi Jinping rule of law thoughts. It's the first time ever that it's being put in that high position and also the systematic way to approach the rule of law. And I actually had a lecture basically given by a colleague, Mr. Xu, President Xu, also Zhenfai, Xiaozang, yeah. Anyway, that is a good speech. In 2019, 2021, I went back to China, after practice, was still practicing lawyer, and became a professor in the university. Some of you might have heard of it. It's called the University of International Business and Economics. In China, it's called Maoda. And I delivered a lecture mostly just on the rule of law. It's called the Judicial System in Common Law Jurisdictions. It's covered the US, UK, and Australian, legal part. It started from, Magna Carta, maybe 1215. As far as the West is concerned, maybe that's a starting point of rule of law. And my students catch up all these things quite well, and they basically enjoyed with this understanding. That's one thing. And also, I know a lot of Chinese lawyers. Well, this is a new one. They have big law firms. As I said, that 40-something years development is also development of rule of law, and also the development of law firms. When I was a teenager, or when I was 20-something, there's virtually no law firms in China. Now, China has Danton, Dacheng. Okay, that's one of the largest law firms. We have quite, the law firm has luxurious, splendid or premium, prestigious offices, all that. So in that, you can see that law matters much more now than when I was young. And being a law teacher or law professor is being respected quite well. You can feel that in China now. And also law is an area that the young kids, university, exam entrance, they want to go to good universities such as China Political and the Law University to pursue laws. And the law is actually it's also a well-paid occupation in China. Okay? Some of the judges, prosecutors, okay, they retracted from their quite prestigious position in the prosecuting office or in the court, and they become a lawyer. See, you can see that law not only matters, and the law also that became more attractive in the career pursuit in China. And the last part, which is very important one, is also a challenge, okay? The China has a tradition that connection matters. And if you don't know anyone in the hospital, you do not go to hospital because you will be treated not that well sometimes. There is such an issue. Well, there is some tradition on that. So that is the challenge. Personally, I believe that legal education should be carried out more in a wider field, to more wide audience, so that law can be more rooted in everybody's mind, so that everything because the root of law is the equality, okay, on top of transparency. So if we have, the China has the equality, then you don't really worry to go to hospital because you will be treated as one of equal. But I don't think that it is yet the case yet. So there is a challenge. That challenge the China has to face, and to make everybody, you go to the good university and good high school, all that sort of issue. If you don't know anyone, it's become harder. It's still that I think that's still relatively. Well, it's getting better, but still, it's not totally wiped out. So in that respect, China still have a long way, okay? Have still a way to reach the rule of law in the more wide, well accepted in the society. As far as compare with the country like the United States, United Kingdom, okay, they still have a way to go, and in a way maybe, but think about it. In 40 years, we don't have a lawyer. Initially, our legal system, lawyer was regenerated, I think in 82, to now, 40 years. What a development! So please, have a confidence. Have your trust on China development in terms of rule of law. Thank you.
Thank you, Professor Tang Lin. He talked about what the rule of law at present in China is. From his personal perspective, based on practice law as a practice lawyer in China and Australia, and teaching law in the law school. And that's a good remarks. I think his remarks will inspire us more and more thoughts about rule of law in China. Our next speaker is Professor Tong. Professor Tong is Associate Dean at Wuhan University Institute of International Law. Now, please.
Okay, thank you, Mr. Chairman. So it's my great honor to be here to take part in the World Law Congress, New York 2023. Since our panel titled Rule of Law, Chinese Perspective, and I'm a professor of international law, so I would like to address a recent important event, which is the launching of a new international organization named the International Organization for Mediation, which mainly initiated by China and several other countries. So on November 1st last year, the Ministry of Foreign Affairs of China announced that it will work with relevant countries to jointly establish the International Organization for Mediation and reach an arrangement with the Hong Kong Special Administrative Region government to establish a preparatory office for International Organization for Mediation, so which will be responsible for organizing and conducting negotiation on the relevant international conventions and laying the institution foundation for the eventual establishment of the International Organization for Mediation. So on this year, February 6th, the establishment ceremony of preparatory office of the International Organization for Mediation was held in Hong Kong. So countries that already signed the joint statement on the establishment of the International Organization of Mediation, including China, Indonesia, Pakistan, Laos, Cambodia, Serbia, Belarus, Sudan, Algeria, and Djibouti. So why did China initiated the establishment of the International Organization for Mediation? So I think the reason are at least mainly based on the following 3 points. So the first reason is, as we all know, the international community is currently facing many difficulties. So the factors of instability and uncertainty of the relationship between major countries, the international order, regional security, and the global governance system are increasing, and the deficit in governance, trust, peace, and development are growing. So the world is facing the danger of relapse into fragmentation and even confrontation. So countries need to work together to cope with crises and challenges and strengthen global governance, resolving crises and conflicts through cooperation and innovation. So the second reason is the international dispute settlement mechanism, especially for resolving disputes involving countries, is facing significant reform opportunities recently. For example, the WTO dispute settlement mechanism meet difficulty with the so-called appellate body crisis since 2019, which mainly caused by the United States blockage of the appointments to the WTO appellate body. So as the appellate body is unable to hear new appeals, so law disputes can now be resolved as the highest instance. So this causing widespread concern in the context of escalation global trade protectionism. So another example is investor-to-state dispute settlement. We call it ISDS. So the ISDS mechanism, which also falling into a so-called legitimacy crisis and lead us through a thorough reform. So this reform is being carried out at different levels of investment treaties and dispute resolution institutions, especially under the leadership of the third working group of the United Nations Commission on Trade Law recently. So the third reason is resolving disputes through mediation have already attracted global attentions. So with the field of international adjudication is currently in a difficult time. So mediation as an earlier and effective conflict management mechanism is attracting increasing attention in recent years. So this can be evidenced by a series of achievements made by the international community in the field of mediation, such as the Singapore Mediation Convention, which is signed in 2019 in Singapore, and the new development of mediation rules, such as new rules published by the ICSID and UNCITRAL and other institutions. So as for the impact of the establishment of international organization for mediation, I think firstly, it will provide a new platform for peaceful resolution for international disputes. So as the world's first intergovernmental legal organization, it will dedicated to the settlement of international disputes through mediation. It will provide a new platform for peaceful resolution of international disputes. So this is an important effort to practice the principle of settling international disputes by peaceful means, which is enshrined in the UN Charter. And secondly, it will help to overcome the shortcomings of existing the international dispute resolution mechanism, such as the limitation of the litigation and arbitration in which one side wins and the other loses. But the International Organization for Mediation may fully leverage its unique strengths of being flexible, cost-effective, and convenient, and present a new option to our country to realize double-win cooperation between disputing parties, so which is of high significance for promoting world peace, security, and development, as well as stability of the international order. So the third one is help to promote the diversification of global governance structure. So it will also be a global public good for rule of law provided to the international community to advance the development of the global governance system. And finally, I would like to discuss some principles for the establishment of international organization for mediation. So, as an important manifestation of China's contribution to global governance wisdom, I believe the establishment of international organization for mediation should continue to adhere to the principle of extensive consultation, joint contribution, and shared benefits, and hold that the future of the world should be decided by our country together. So this new organization needs to stay inclusive and draw inspiration from various civilizations and legal systems. So it will welcome both developing and developed countries to join, especially enhancing the participation of developing countries and training mediators from developing countries, and work to make the international dispute settlement mechanism fairer and beneficial to all. So I would like to stop my speech here. Thank you.
Okay.
Thank you for listening.
Thank you very much for your wonderful speech. Professor Qi Tong talked about the dispute settlement. You know, in the world, there are many, many disputes. How to deal with, how to settlement disputes. Just two ways. One way is a peaceful settlement. Another way is unpeaceful. So we have to look for the peaceful settlement. The legal ways are good, peaceful dispute settlement. So Professor Qi talked about this. Okay, our last speaker is Professor Shenjian. Professor Xu is a Dean of School of Jurist Master. He's my colleague from China University of Political Science and Law. I just want to explain what's what a jurist master is. You know, in the United States, we in the law school we have a JD program. You know, after undergraduate study, you can go to the law school to study for JD degree. China share American law school experience. We introduced the seminar program, the JD program, but we haven't called JD. We called the GM. We think the JD is just a graduate level, master level, not a PhD level. So we called it Juris Master.
Yeah. So yeah, thank you, Chairman. So give us a very excellent explanation. What is GM? In one sentence, so in China, the GM is equivalent of the American GD program, GD. So, so the mainstream of American law school is GD. So and you have some LLM and SJD. So, but in China we have more complex legal education. So we have the PhD program. So it's very difficult to list to some kind of GD, Juris Doctor, so GM, is one word. And thank you, Chairman. Good afternoon. I'm the last speaker, so I really want to be the least speaker. Okay. And good afternoon. It's my honor to be here to share with you the development of the Beijing Internet Court and its impact on the legal profession. With the continuous development of information technology, China is gradually moving into the era of the Internet, data and intelligence. In the case of China, China was fully connected to the Internet from 1994. The development of the Internet can be described as ever-changing and updated until the 2022. By December 2021, the number of Chinese Internet users had reached 1.032 billion, and the Internet penetration rate 73%. Beijing, as the important member of the first engine of the nationwide Internet development, ranked first in China in the aspect of the population of the Internet users and the Internet penetration rate. Internet enterprises gather in this area and developed in a diversified way with a strong momentum. As the Internet technology develops rapidly and becomes widely applicable, the number of Internet-related cases is continuously increasing within the Beijing jurisdiction. Really on the series of accomplishments brought by high quality growth of the Internet, Beijing has further explored a new development path combining the Internet and the rule of law. In particular, the emergence of the Internet court has enabled the legal disputes encountered by people in their daily life to be solved in a more efficient and fair manner. The more convenient way of launch digital litigation saves the cost of litigation and is conform to the current litigation psychology and judicial needs of the public, especially in the context of the COVID-19 pandemic this year, the Beijing Internet Court has been playing a significant role and has gained far-reaching development. This novel judicial category affects legal profession to some extent as well. My speech today will focus on two issues: the development of the Beijing Internet Court and its impact on the legal profession. Firstly, the development of the Beijing Internet Court. The establishment of the Beijing Internet Court is a product of the progress of times as well as judicial and social development. The establishment of the Beijing Internet Court keeps in line with the trend of the times, and it has strong practical needs. This year makes the 20th anniversary of China's access to the international internet. Looking back at the road we have traveled on through 84 of the twists and turns, moving forward is with our determination. The development, reform, and innovation of Chinese internet industries have gradually blossomed and been harvested. With the rapid development of the internet, more and more internet disputes arise. Thus, there is an urgent need for creating a specialized court at the judicial level, which has a professional term and professional technical means to deal with the internet-related issues. The establishment of the Beijing Internet Court is also an important achievement for China's internet judicial development. Since 2013, in order to further meet the diverse judicial needs of the public, local courts around the country have been actively promoting the internet judicial practice in areas of judicial transparency, multiple dispute mediation, litigation service, trial implementations, etc., under the coordinating and promotion of the Supreme People's Court. Based on these foundations, the establishment of the Beijing Internet Court could further enrich the judicial practice concerning the internet and improve the judicial system of the internet. Also, establishing the Beijing Internet Court can strengthen the capacity of comprehensively governing cyberspaces and promoting the building of the security system in cyberspace. Moreover, the establishment of the Beijing Internet Court is an inevitable requirement for exploring the legal rules in cyberspace governance. The establishment of the Beijing Internet Court fully reflects innovation and advanced nature of judicial reform. In terms of the case jurisdiction, concentrating jurisdiction is important, is implemented based on the provisions of Supreme People's Court and several issues concerning the trial of cases in the Internet Court. The Beijing Internet Court shall have centralized jurisdiction over 11 classification of the first instance Internet cases within Beijing that should be accepted by the local people's courts, mainly including the civil and administrative Internet cases arise from the online shopping, networking service, financial loans, infringement of the intellectual property, property rights, personal rights, property rights, etc. On Internet, unlike those traditional courts, the Internet court mainly have the jurisdiction over online disputes and implement its unique litigation rules. Specifically, online disputes shall be tried and completed online, namely the two-line litigation models, which fully demonstrate the criticize the Internet court. In addition, since civil and administrative cases occurring in the Internet area, both accepted by the Internet court, and the Internet court have comprehensively jurisdiction and monetity and its feature. In terms of the manners of the case trial, the whole process of case trial is conducted online. In order to better realize the goal that online disputes shall have tried online, Beijing Internet Courts have concentrated on intelligent electronic litigation platform so that the entire process and task can be fulfilled online. In terms of the archiving the cases, a blockchain analysis judicial blockchain platform was built. Evidence is often present in the form of the electronic data among the 11 types of Internet cases accepted by the Beijing Internet Courts. Using the jurisdiction as a foundation to establish rules, further creating a higher level of digital justice. Second, the impact on the development of the Internet court on the legal profession, and significantly improve the efficiency of the judges' trials. The Beijing Internet Court has built an electronic litigation platform by a united number of Internet technology companies and absorbing the cutting-edge technology. And also effectively saving lawyers' working costs. The establishment of the Internet Court and the development of the artificial intelligence technology have an impact on the legal service industry, has resolved the disputes more efficiently, as well as the saving the cost of the legal work. The content and the method of lawyer work have gradually changed. And finally, in the long run, the Internet technology is changing constantly. In addition to artificial intelligence, big data, and others, there will be more new things and challenge endless emerging. People will live their lives in all aspects within virtual spaces. These virtual spaces need both direct regulation by law and a new type of the judicial model to lead it. The establishment of the Internet Court is inevitable necessity and accessibility. It is a fact that only China has established Internet courts in the world. Along some other countries have launched online court hearings for their traditional trials, as well as the promulgating the laws on the e-justice. Rather have not yet created a unified Internet court to accept Internet cases. As the construction of the China's Internet court keeps on moving forward, more and more experience can be gained, which could lie on a solid foundation for the progress of the Internet litigation system, and other continues can draw on China's experience for reference. In the meantime, human society is accelerate its migration to the online virtual world, which will build a brand new set of social rules. The mission of the contemporary legal professionals is to participate in establishing the set of the rules. It is a historical opportunity and great challenge for all the legal professionals. Thank you.
Thank you, Professor Xu, who talked about the new development of rule of law in China. One one point. We have set up 3 internet courts in China, dealing with the digital or e-issues. Yeah. Thank you. Now all the speakers have made their excellent presentations from their respective perspectives. Now we have 5 minutes. Yeah. Now I open the floor for the question and the comments from the panelists and all the persons. Okay. Okay. Yeah, maybe you can. Yeah.
Thank you. So thank you very much and welcome to our Chinese guests here in New York. My name is Lawrence Moss. I'm the Human Rights Lawyer in New York. And of course, China's been remarkably successful economically in economic liberalization under the guidance of the Communist Party and has indeed instituted many rule of law advances for commercial disputes. Taiwan has also been very successful. It poses a very different model of economic development, but under a different
as a successor part of China.
Yeah, and as a part of China, and you know, as the leading manufacturer of semiconductors in the world, advanced semiconductors, and dear to my heart, as the leading manufacturer of carbon fiber bicycles. But it's had a different model. It was originally an authoritarian state under the KMT until 1987, but since then it's progressed into a multi-party democracy. Jerome Cohen, the leading American expert on Chinese law, just published a book recently on the remarkable transformation of Taiwan in international human rights. They've basically taken the provisions of the International Covenant on Civil and Political Rights for domestic law. And so my question really is, and also has become the first country, I think, in Asia to acknowledge same-sex unions, same-sex marriage, whereas China's been moving the other direction. There's been less tolerance on that, as an article in The Economist in May of this year pointed out. So my question with Chinese friends, is there anything that people in mainland China feel they can learn from the Taiwan experience? I mean, Justice Brandeis in the United States talked about states as laboratories of democracy, that they would help pave the way. Can China learn from the experience of Taiwan and say in some way that Taiwan's advances would be incorporated, especially in trying to persuade Taiwan to engage in peaceful unification? Because the people of Taiwan probably don't believe that's in the cards. The experience of Hong Kong has been that one country, two systems seems to be an empty promise. So that's really my question, is what can China learn from Taiwan?
I ask my colleague, Professor Tang, Zhang Laigeng, answer this question. my understanding, any boss can fire employee without any reason, and any employee can go out without any reason. But in China, we have something, for the contract, and you must give some reason. So that depends on different countries and different situations. So I would suggest first I visited Taiwan many times as a professor, take academic exchanges. So also I talked to some professors from Taiwan. So we have already know each other, but also we want to promote more, particularly for the young generation, to know each other. I think we'll go. And also I have questions for Ed. That I first raised my hand because I'm very interested in your question on the transparency, because transparency is a critical requirement for the rule of law in any country, universal. And I think particularly important for the business, for people doing business in China. You may know that China and other countries to initiate conclude the negotiation first multilateral convention, a treaty on investment in the retail. Priority is transparency. So I wonder if we have time result, and what's the main issues for your practice lawyer, transparency in China, and particularly for business?
Good question. Do we have time?
Yeah. Maybe you answer the question first.
Okay. I think that there's an increased transparency, as I noted, in the judicial system in China. And I think that needs to continue because that's critical to commercial investment. And I think the view of many Western commercial interests is that there's more transparency and there's more of a fairness process in some locations than in others. So, for example, Shanghai, Beijing, places like that, there's a higher level than in some of the quote smaller provinces, where there's been more troubles with transparency. The other part of that is, it was touched upon earlier of going to people in your circle of relations and achieving a result which is culturally, as I understand it, the norm in China, and as was touched on in a couple of the presentations, that is very much a part of China. That process, particularly when there's corruption involved, is a real problem. And I mean, I know that Xi Jinping has the anti-corruption campaign, and it's been actively pursued to a fair level. Obviously, the United States has the FCPA. Hong Kong has a similar legislation. Most countries have a similar legislation. The more that can be enforced, and maybe more importantly than enforcement, but respect of it, where the custom is not to seek corrupt means to get an end. I've seen some very bad corruption. And in one case, not that any of us would like to see it end that way, but it ended up in a bunch of individuals going to jail in China, and one judge was executed as a result of it. So the less that can happen, the more faith in the system will exist. And that was one of the reasons that, I pointed out CTAC. I think CTAC is a very good process. And it has many attributes of many judicial systems. Not to say ours is the best or English is the best, but it's a process where both sides present, and there's a fair amount of transparency and preparation. And I've been involved in a number of CTAC arbitrations where I think they're every bit as good as any other court anywhere. I mean, it's not a court, but it's an arbitration panel. The thing that I'd sort of like to close on your point is trying to, as an American lawyer working in Asia, and particularly China, or any non-American jurisdiction, I think it's critical that the lawyer and the clients respect the culture of the home country that they're doing business in. And you can't sort of go in and say, well, this is the way we do it in New York. Well, you're not going to do very well doing that. So one of the things that I think is important, and I think there's a harmony between the cultural customs in China and rule of law, where they sort of marry each other, is that the more developed the legal system is in a country, the more people will be able to negotiate amicable resolutions outside of court, because I very much recognize that it's not consistent with Chinese culture to go to a public forum and resolve your disputes. And on the US side, we're probably too prone to that. I mean, we sue each other all the time. And that's not the best solution either in many cases. But when I found myself negotiating a solution in China, the most powerful tool is both sides respecting and knowing where they would, or have parameters of where they would end up if they went into a litigation. And that drives the parties closer. So I think that's the harmony in true rule of law and respecting one another's cultures.
Okay. Due to the time reason, I have to say our panel will come to end. I'd like to say thank you all of you, organizers, panelists, and attenders for your wonderful presentation and successful discussion. We have time. Yeah, maybe during the meeting, during the Congress, we have time to meet each other. We talk about some issue each other. Yeah, thank you.